All right, welcome back. This capsule is dedicated to the case of Law v. Canada. This is the end of our two sections on general principles under Section 15 of the Canadian Charter. Specifically, this is the Monday of the second week, and this is a very, very important case, probably the most important session of the semester, because we really look at the broad principles that apply to Section 15 claims. It's stuff that's going to be useful throughout the semester, and specifically to the principles that apply under Section 15, subsection 15.1. It's significant, of course, because subsection 15.1 is going to apply a lot more than subsection 15.2. So you'll recall, right, Section 15 of the Canadian Charter is the guarantee of equality and non-discrimination. Subsection 15.1 says you have a right to be free from discrimination and to be treated equally under the law, right? And a bunch of other things. And subsection 15.2 says, subsection 15.1 is not to be construed as basically preventing the government from enacting what we call ameliorative programs. So basically when the government, as I said on our very first session, right, discriminates but in a way that is okay. So discriminates but in a way that furthers non-discrimination. So the government affords, for instance, specific rights or privileges to specific groups of people to make us more equal, right, to remedy historical disadvantage. Well, of course, subsection 15.1 is the one that can allow you to invalidate a law because it's discriminatory, and so it's going to apply a lot more than subsection 15.2, which is this, second step very often where the government can save a law by saying, although it's discriminatory for a good reason. In our last session, so Wednesday, we looked at a case on subsection 15.2. I did it in that order because it's easier, and that case lays out a lot of the broad principles, right, for subsection 15.1 as well, but essentially it was a case about subsection 15.2, so about ameliorative programs. So the government, right, showing, so how the government can show what the steps are, what the evidentiary burden and the evidentiary weight is to show that a program has an ameliorative purpose and therefore is discriminatory for a good reason. Well, for this week, we turn back to subsection 15.1, right? And that's the most significant. We're going to look at all the broad principles. So this is why it's going to be the most important course of the semester. First of all, right, what do we see? Law v. Canada. So someone, a lady called Mrs. Law, right, is suing some government entity. Why is that significant? It's significant because, as I said, the Charter applies in a relatively, arguably narrow range of circumstances. So the Charter prevents the state from discriminating against you. This Charter does not apply to relationships between private individuals. So you'll recall I said there's no such thing as you saying, I went into a convenience store and I was treated discriminatorily. Because the Charter doesn't apply to your relationship between you and the convenience store clerk. Only applies to our relationship with the state. You'll recall as well that I said that's still quite a bit of stuff that can be struck down because, namely, laws are passed by the state. And therefore, any law generally passed by the government, right, in that case the federal government, can be struck down because it's a relationship between the state and citizens, right, that's subject to the Charter. So Mrs. Law is suing some Canadian government entity, hence why Canada is the defendant. This case from 1998, why is that significant? Charter was passed with the amendment of the Constitution by Trudeau-Pare, brought it back to Canada, added the Charter 1982. It's a relatively early case, as we'll see, right, the broad interpretive principles. So, right, the background on Section 15. What it does, what it's for, how it should be interpreted, that still applies. Many of the tests still apply. They've been simplified, but still it's good to remember that it's a case from 1998, and therefore, right, the case law has evolved somewhat in its interpretation. First page on appeal from the Federal Court of Appeal, not a provincial superior court, as was the case in our last session. So we'll adopt the same approach here as I did last week. First, we'll look at kind of a summary of the case without precise paragraph references, and then we'll go into more detail. As I said in our last session, you should never cite to the headnote of a case, this summary that comes at the very beginning, because that's not actually part of the case, doesn't have force of law. So if you're writing a paper or answering a question on an exam, then you should refer to the paragraph in the actual case. And of course, there's always going to be a paragraph in the actual case that says the same thing as the summary, but in some more detail. Specifically, you'll notice that there's something that we call a neutral reference. So sometimes, right, what comes after the style of cause, as we call it, right, so the name of the case, Law v. Canada, right, often it's going to say year, then SCC, and then a number. That's what we call a neutral reference, right? What does that mean? It means that, so it's 2015 SCC 9. Well, 2015 is the year, obviously. SCC is the Supreme Court of Canada. And then 9 means it's the 9th case that was decided in that year. It's not always the case, even though it seems pretty easy for the Supreme Court to count how many cases it decided in a given year. It's been done relatively recently. So for instance here, 1998, there's no neutral reference available. Significantly, when there's a neutral reference, there's also neutral paragraph numbering. And so you'll see paragraph numbers in the versions I give you, right? Then you can cite to the paragraph number. And once you know that you can cite to the paragraph numbers, well, first, there are paragraph numbers that are in text as opposed to in the margins, but also there's a neutral reference. So if there's a year SCC something in the citation, then it means you can cite to a paragraph number. If not, you're supposed to cite to a page number in what we call a reporter. So here the case doesn't have a neutral reference. 1998 was published in what we call a reporter. Basically, someone assembles all the case from the Supreme Court, right, and publishes it. In that case, it's what we call the Supreme Court reporter, which is produced by the Supreme Court. And that's why you have this pagination there that you were given. And that's why the case begins at page 497. So in that case, because there's no neutral reference, right, your precise reference should be to a page number where the relevant paragraph that you want to cite appears. So what happens in the case? Well, you have Mrs. Law, 30-year-old woman, doesn't have children or disability. Why is that relevant? Because that might change her eligibility for the Canada Pension Plan. Then her husband dies, right? And there's what we call survivor benefits, where if your husband dies, you basically get a portion of their pension. So you're protected, right? In the sense that, right, if your husband had been alive, he likely would have paid for a portion of the household expenses. If he's dead, that's not the case, and therefore survivor benefits allow the widow in that case to be able to shoulder that financial burden by giving her often a portion of the pension of her husband. But there's a rule that says, right, you only get the full pension of your husband if you're 45 and older. If you're under 45, then it decreases proportionally per month, I think, right, from 45 to 35, such that at age 35 you get nothing. There's a full reduction of the amount that you would get. Well, Ms. Law says, of course, right, that this is discrimination against her based on, of course, age. That is an enumerated ground. So you'll recall from last week that subsections 15.1 and 2 both have a list of things, right? So they say you can't discriminate against people notably based on, and then there's a list of things. It's the same in both subsections, right? And it's a list that is not limitative, and therefore you can discriminate based on things that are not in the list, but then the person is going to have to go to court, you'll recall as I said, to prove that it is what we call an analogous ground, right? So something similar that you can discriminate upon, and then it doesn't have to be proven again, as a side note, as I said last week, right? Once the court's recognized it once, in further cases you don't have to show again that it's an analogous ground. Of course, you'll still have to show that there was indeed discrimination based on that ground. Here, age is in the list. It's an enumerated grounds. It's in the list in both subsections. And then, of course, the Supreme Court does, right, what it often does, right, says, wow, this is a tremendous opportunity for us to recap and reframe the entirety of the law under subsection 15.1 of the Charter, and then Mrs. Law really is this kind of an opportunity for us to do that. And you see, right, that there's about 10 pages at the very most out of the 67 or so that are dedicated to applying these principles to her situation. That's why it's an interesting case for our purposes, but it's not unusual for the Supreme Court not to be concerned particularly with the facts as much as it's concerned with the law or what the law should be. Supreme Court says, right, there's been lots of interesting developments in equality law, and this is an opportunity for us to basically set out what these developments have been and clarify the law in a number of important principles. First, right, the analysis has to be purposive. So we mentioned that both Monday and Wednesday. It's significant because it underlays both subsections of the Charter. Purposive means we want to achieve what we said last week is substantive equality. So not a narrow conception of equality, which we might call formal equality, if people being treated the same and where not being treated the same might be construed as discrimination, but instead what we call substantive equality, where people are treated the same in effect. And therefore, oftentimes, to treat people the same, it's going to be necessary to take into account historical disadvantage and the ways in which people have existing unequal access to various services or things that might be affected by a law. And the court is going to enumerate a number of contextual factors, right? And these are not as relevant today, but they're still helpful interpretive aid. So there's stuff that remain relevant in what you can look at to assess whether there's been an infringement of Section 15 of the Charter, even though you don't have to prove, either all these things or a number of them to succeed. And it's also what the court refers to as the remedial purpose of subsection 15.1 and 2, right? Where the purpose of it is clearly set out in subsection 15.2, among other things, right, is to remedy existing inequality. So it's not just to say, right, we want to proactively make sure people are treated equally. In fact, there's a recognition in subsection 15.2, again, that says the government can enact programs to combat existing inequality, right? There's a recognition that the purpose of Section 15 of the Charter is not just to ensure equality, but also to proactively make things better, because there's a recognition that there isn't the same access to various things, there isn't substantive equality as it is now, or at the time it was enacted in 1982. Then you have three factors there that are not the test, right? So subcap number 2, page 4, whether the law has differential treatment, right? Whether it's on the basis of an enumerated or analogous ground, and then whether it has a purpose or effect that is discriminatory within the meaning of the equality guarantee. So what I'll do now is I'll frame it as it is today, because as I said, and you don't have to get confused over this, the relevant stuff is in the case. It was reframed a little bit, but this is still the best case to learn about these principles if you don't want to read the entire case law. So you'll recall I gave a taxonomy that was somewhat simpler last week and correct, right? So first, right, there has to be, sorry about that, there has to be a distinction and second, it has to be discriminatory. Okay, so first of all, there has to be a distinction. In other words, right, people have to be treated differently, right? So the group of people who are coming to court and claiming discrimination have to be treated differently than someone else, right? Some other group of people. We'll look at what that means in greater detail. They don't have to all be treated differently, right? There's all sorts of issues about the comparator group that are not as relevant today. So identifying the comparator group is no longer as much of a focus, right? In terms of finding people who have the same characteristics but then are missing the thing you're discriminating upon, you don't have to worry a lot about that because it's not as relevant today as it was then. The court kind of recognized it. Too much focus and time was expended on trying to find and define a comparator group. That being said, the principle remains true, right? You still have to be treated differently, and by import, right, you have to be treated differently than someone else or some other group. But not every distinction is going to be discriminatory within the meaning of the provision. Why is that? Well, first, sometimes you can have a distinction that is legitimate, right? So in that case, for instance, and that's just one example, right? In that case, misses the law, right? The court eventually finds distinction is not discriminatory, right? Because there's a distinction, but it's one that is legitimate, right? It's a distinction that doesn't prevent people from accessing services or that furthers existing disadvantage, and therefore we need the distinction to be discriminatory. It's also significant because, right, because we have the grounds. So you'll recall I said you can't have a law that's discriminatory against Caucasian people. Of course, you can have such a law, but not one that's going to fall within the meaning of subsection 15.1 of the Charter. Because subsection 15.1 and 2 prevent against discrimination against basically people who have traditionally been discriminated against or marginalized, doesn't protect majority Caucasian group. And therefore, you might have discrimination against Caucasian people. And the law might be discriminatory in the sense that it treats people differently, but it's not going to fall under the provision because it's not on one of the grounds. The distinction has to be on an enumerated or an analogous ground. And the court in this case kind of conflates it into 3 steps, right? So the court says first whether there's a differential treatment, second whether it's an enumerated ground, right? And third, whether it meets the purpose of the law, of the provision, which again is to protect from discrimination against people who have been traditionally marginalized, and on top of that to achieve substantive equality. So I'll break it down this way. I think it's simpler to put the grounds under the first step. It doesn't really matter. The distinction eventually has to be based on an enumerated or analogous ground. I think it's more correct to put it under the first section because really, if it's not one of the grounds, it doesn't even count as a distinction within the meaning of the provision, but again, doesn't really matter all that much. Second, distinction has to be discriminatory. So first, right, quite obviously there has to be discrimination. So it has to be something that treats people in a way that is not responsive to historical disadvantage, right? That violates their human dignity, their ability to participate, as the court says, as full members of Canadian society. It has to be about that, right? It has to be something that, and the court says it's an elusive concept when it's hard to define because it's true, right? It's kind of hard to define, but it has to be something that offends their sensibilities, their sense of the respect that people deserve, their dignity, their ability to participate in society, and then, which the court puts as a distinct step, has to meet the purpose of subsection 15.1, right, which is to protect against discrimination for specific groups, people who've been traditionally disadvantaged, and second, to achieve that conception of substantive equality. But again, we make much of this, right? It's not really that complicated. Distinction has to be discriminatory within the meaning that's ascribed to that word by the case law. And then you have, right, a couple of steps about how closely the distinction and the treatment are related. We'll look at that in greater detail later on in the case. Then under the section purpose, I'm now at page 500, right, or the fourth page, whether the differential treatment, right, as I said, prevents people from participating in Canadian society. Then the comparative approach, right? We don't have to worry about that all that much. As I said, the court says the person chooses the comparator group, right? So the plaintiff, the person that's claiming discrimination before the court, is going to have to pick at first hand, right, who the comparator group is, but the court's allowed to reframe that, right? So the court's allowed to say, right, you picked it in a way that was not advantageous to you as the plaintiff, as the person that's trying to show discrimination, and therefore we reframed it. That's basically what the court says. Then, right, the point of view, as the court calls it, right, so the standard that we apply, right, we'll call it a reasonable person, but. And so that's defined, of course, page 501. I'm again in the summary. There's a corresponding paragraph later on. So the reasonable person, right? Why is that important? So first, the court says it is both subjective and objective. So why is that? And that is very significant. First, subjective because we look at how the specific person or group that's coming to court is treated, right? And that makes sense, right? They're claiming discrimination. Essentially, they're claiming that there's a treatment that is unequal or that's unfair to them. Well, of course, we're going to look at the impact. So if the treatment in that case is, to give a concrete example, Mrs. Law doesn't get her husband's pension. Well, that's the impact on her. The impact on her is she doesn't get the money. That's a significant impact because it was a lot of money. She would have had it for her entire life. That's the subjective portion. Of course, we look at the specific situation of the claimant, the plaintiff, and the impact upon the claimant, the plaintiff. Objective because we look at basically historical data. So within the meaning of what I said is discriminatory, right? Because we only protect against discrimination to people who've traditionally been disadvantaged. So a portion of the focus is going to be on historical the historical situation and treatment of people who are similarly situated. Well, in that sense, it is objective. It's not specifically concerning the person that's in court, it's concerning other similar people, both present and past, and how they have been treated. Then the court gives a bunch of contextual factors. I won't write them down because there isn't much room, but they're all very relevant. The court recognizes that the list of factors is not closed. So what does that mean? Again, in the same way as the list of grounds, it is not limitative. Therefore, you can, find other relevant contextual factors, and in the same way, you don't have to prove all of them or a number of them to succeed. They're just helpful interpretive aids. And regardless of how their weight might have fluctuated between 1998 and now, they all remain, stuff that is relevant to look at in proving an infringement of subsection 15.1. First, pre-existing disadvantage, Let's just write down contextual factors here, and you should look at them as I said, interpretive aids. First, pre-existing disadvantage. This is pretty intuitive. The court looks at how people have traditionally been treated, and if they've traditionally been disadvantaged, that's going to help in future cases show that discrimination is perpetuated by current action, often in the case, as here, of a law that draws a distinction. Second, whether the government, passing the law has considered the actual needs, capacity, or circumstances of the claimant. So that's relevant because we expect that, as we'll see, We expect the government to have an approach that is responsive to people's characteristics. And we'll look at that in greater detail, but that's very significant factors, and it's a high burden to place on the government. So you'll recall I said a law can be discriminatory in its purpose or effect. I said that last week. It's true, So the law doesn't have to say you get a pension unless you're a Jew. That is discriminatory, arguably, in its purpose, and the purpose is to take money away from Jews. Well, that's not very often the case in equality and discrimination litigation, There's not that many laws today, and therefore the impact is often going to be more nuanced, We're going to impose something that is apparently neutral, like a holiday on a Sunday, that's going to have an unequal impact, on people. So if your religious holiday is not on a Sunday, say, well, then it's going to have a greater impact on you because that holiday is going to fall on some other day. It's going to prevent you from celebrating your religious holiday. This is a discriminatory effect. Significantly, one of the contextual factors I've just mentioned is the ways in which a government's been responsive to the actual situation of a group. So the government can't just pass the law that says the holiday's on the Sunday and say, well, we didn't either say, to backtrack a little bit, the government can't either say, well, it's fair because it applies to everyone, period. That's not a proper justification. It's not enough, and it's not what we expect from the government. Second, the government can't say, we didn't think about it. We didn't think of the fact that some people have their holidays on something else than a Sunday. That's also not enough. Because one of the contextual factors, and that's part of the law now because of Supreme Court precedent, we expect the government to look at the situation of the people affected by the law. So that means essentially in my example that we expect the government to say, well, how is this law that does something on a Sunday going to affect, and then take all the groups of people who are affected and see whether, it is a disproportionate impact. Another contextual factor, C, I'm now at page 502, right? And this is the one that's no longer true, whether the law has an ameliorative purpose. I discussed that last week at great length, right? The ameliorative purpose is now distinct. So this is about 15.1. We no longer look at whether there's an ameliorative purpose under subsection 15.1. We look at that under subsection 15.2, which basically says laws with an ameliorative purpose are allowed. Of course, it was still in 15.2 when that case was decided, but the court at the time hadn't decided whether 15.2 was a way to interpret 15.1, or if it was a distinct, right, a distinct ground to defend the law. Subsequently, the court says, yes, it is distinct. You read the case on last Wednesday that specifically said that. The court says it's distinct, can save a law on its own. So not just say, well, maybe it's not discriminatory because it does something good. Instead, can say, although it is discriminatory, we can save it because it says something good. So that's the contextual factor that no longer applies. D, the scope of the interest affected by the impugned law. Right? Again, as I said, in our specific case, Mrs. Law doesn't get her pension. This significant interest is affected because she loses a lot of money and it's important to her. The court says, quite helpfully, if it corresponds with human dignity or freedom, it's more likely to be significant interest. Why is that? Because of that purposive interpretation. And the purpose is to further substantive equality, right? People to be equal in effect. So of course, if the interest affected is such that a person gets lesser access or participation in Canadian society, affects her dignity, well then that falls under the very purpose that we are trying to further with that legislative provision. And the court concludes on the case here that there is a distinction. Why is that? Well, of course, because you do treat people differently, right? If you're 45, you get your pension. If you're 40, you get less of a pension. If you're 35 or under, you get nothing. Well, that is clearly a distinction, and it's one that's based on an enumerated or analogous ground. In that case, an enumerated ground, because it's written down, and that is age. But it's not discriminatory. Why is that? Because it doesn't further a stereotype, or any of the things we said really. Doesn't further a stereotype, doesn't attack Mrs. Law's dignity, doesn't prevent her from being a full and respected member of Canadian society, etc., right? All these things we said that are contextual factors, right? Of course, right, there hasn't been a historical neglect by the government of people who are 35. And they aren't people who've traditionally been prevented from participating in Canadian society, or people where taking their pension away, right, does just that. In fact, generally, they're people who can get more participation. So in that case, right, the goal of the pension is basically, as the government says, and the court confirms, right? So court doesn't just go off what the government says, as I said, right? Last week I said government has a purpose, so the court is not going to look at whether it achieves that purpose, but the court's going to look at whether it is sensible. So here, government says our goal is to protect people, right, when their husband dies and they can't get a job, right, or can't ensure their financial stability on their own. Well, right, in that case, if people can't assure their financial stability, right, it does make sense to provide them with a pension, right? And so it's sensible. And that's what the court, that's the exercise that the court's going to do to check the purpose. So court isn't going to check whether there's statistical evidence to the effect that providing a pension helps, further that financial stability. It doesn't have to prove the purpose, right, that the purpose is indeed affected by the law. But the government does have to show that the purpose makes sense. In that case, the court's going to make the exercise and look at whether it makes sense that providing a pension helps people if they can't get a job back and their husband dies. But that does not play into a historical disadvantage for people under 35. In fact, it's quite the opposite. People under 35 tend to have an easier time getting a job. And then there's arguments about, well, they might have a harder time in the short term, right? Or everyone might have a harder time in the short term, namely because their husband just died. But that's not the purpose of the law, right? And again, the focus is on the law here, because we're saying the law is discriminatory. And the purpose of the law is to prevent these longer-term effects of financial instability. And in that sense, there's no reason to think that people under 35 are not better positioned to get access to a job. And therefore, it's discrimination that is not discriminatory. Then interestingly, right, court's going to say a bit later on that there can be many grounds. Why is that significant? Because one of the arguments was, well, under the law, right, not a particularly convincing legal argument, under the law, we don't just look at her age, we also look at whether she has kids and is disabled. So you'll recall I said, right, this law is a non-disabled person with, I think, no dependents. Well, that's why she was not eligible, right? The requirements might have been different if she were disabled or had a different number of kids. And the government tried to say, right, well, the distinction here is not based on age. It's based on age and ability and number of dependents. And the court said, no, right? You can have more than one ground. So in other words, what does that mean? Two things, both of which are significant. First, the law can draw a distinction based on age and ability and dependence and still be discriminatory based on age. So the fact that the law doesn't say it's only about age doesn't prevent it from being discriminatory based on age. Second, the law can also be discriminatory based on more than one thing. So, overlapping cumulative discrimination, right? Might be discriminated upon based on the fact that you are a black woman. That's gender, right, and race. And that's also something that doesn't prevent you from showing discrimination. Seems pretty intuitive. So you can have discrimination based on multiple enumerated or analogous grounds. Another significant issues that we have near the end of the case is this idea of judicial notice. So the court says we take judicial notice of the fact that people under 35 can more easily get a job. What does judicial notice mean? Judicial notice means something that we know that you don't have to prove. Because by default, right, the standard in court is if you want to get something, you have to show something. You have to adduce evidence, right, proof, right? It's generally testimony or either testimonial or documentary evidence, so people or documents, to support what you're claiming. So if you're saying, right, they lied to me, then we'd expect you to have a document or a person that says, that's true, they did lie to you, or, right, the underlying facts that would suggest that they lied to you are established. And you have, as a plaintiff, what we call a burden, right? You have a burden to show that the things that you're alleging did happen, right? So to adduce evidence, to show the facts that then give rise to your legal claim. by default, it means everything, right? So if you're saying, right, good example, when I was practicing litigation, the dad said, that doesn't make sense because it's going to take me half an hour to drive my kids to school in the morning. Well, how do we know that, right? You haven't shown with an expert in traffic that there is traffic in the morning in Montreal. You also haven't produced a statistical study that says there is traffic in Montreal in the morning. So generally that claim would fail, right? The court could not take notice, could not take into account the fact that it's going to take you half an hour to drive your kids in the morning. And that has, significant reasons for it that we won't look at, generally because the court can be partial, right? The court starts believing the dad, then there's an appearance of impropriety and an appearance of a lack of independence on the part of the court. But sometimes a court can take judicial notice, right? What if it's something more dumb, right? What if it's something like March 7th was a Wednesday? Well, how do we know that, right? We don't. Well, in that case, we don't expect you to have a calendar expert that's going to testify for 20 grand and say, well, March 7th was a Wednesday. We also don't expect you to produce a calendar into evidence, right? Otherwise, every court file would have a calendar into it. And why is that? That's because of judicial notice. That's because the court can take judicial notice that we have a calendar that runs for 12 months a year in Canada, and that March 7th, according to the calendar, was indeed a Wednesday. But generally that's limited to some relatively simple concepts because the court doesn't want to be biased, but also because judicial notice has precedential value. In other words, once a court decides it once, it is always true. So you'll recall I said once the court recognizes an analogous ground, then it's an analogous ground forever. You don't have to show again that it's an analogous ground. Well, the same is true for judicial notice. So once the court takes notice that there is traffic in the morning in Montreal, well then, right, in a subsequent case, you don't have to ask for judicial notice again because you can cite the judge who took judicial notice of that as a source, and therefore forever, in every case, people are going to be able to prove that there's traffic in the morning in Montreal. Here, court takes judicial notice of something pretty interesting, of the fact that people under 35 can get a job more easily. That seems to be something that's at the very limit of judicial notice, something that's not that obvious, not something that everyone knows, like the fact that we have a calendar that runs 12 months a year in Canada. Why is that, you might ask? I speculate that it's because Section 15 claimants are generally not the most sophisticated parties, right? They're not people who come in with $850 an hour lawyers who have prepared the case, right? They're generally windows orphans, or people who are defended by organizations that might be working for free or for very little money, and we want to achieve that idea of substantive equality. We want to help people who've been historically disadvantaged. And so that might be why the court's willing to take judicial notice of something that's not that obvious, and it might also be why, as we'll see, the court relaxes some of the evidentiary standards. So the court also says, not only do we use judicial notice, we also use logic, right? So in other words, if something's obvious, you won't have to prove it, generally with a statistical or sociological study. So if you're saying the example the court gives is citizenship, so say you need to be a citizen of Canada to get a job in the police. Well, right, you're not going to have to prove that first. People who don't have citizenship are generally disadvantaged because they have fewer rights. The court's going to take judicial notice of that. The court's going to say, we all know it, it's obvious, like the calendar, we take judicial notice of that. Second, the court's also going to use logic. So the court's going to say, well, of course, if they don't get jobs in the police, they get fewer jobs, and therefore that contributes to the existing disadvantage. Then the court went through the entire syllogism there. So you didn't prove with statistical evidence that, say, people who are not Canadian citizens are poorer. You could have, but you didn't. And second, you didn't prove that getting fewer jobs reinforces that historical disadvantage. Harder to prove, but again, you could have. But the court saves you there, often the Supreme Court, and says we use judicial notice and logic, and that's allowed in the evidentiary burden. So we expect you to do evidence to show specifically what you're alleging, unless, right, we can use these two devices. And often they use them when it's too late, right? When the person hasn't filed it into evidence, and then you're before the Supreme Court, so it's really too late to file new stuff, right? It's too late because you're at trial, and it's too late because it's your third chance, and you can't add stuff in between, but then the court uses these to save you, or at least that might be my speculation. When I get back to this point of view there that I might have glanced over a bit too quick, so reasonable person, subjective and objective, right? I also said but, right? So it's not any reasonable person, right? Because generally, reasonable persons, right, generally meaning anyone, so anyone walking down the street might be a prejudiced, uninformed person, right? You might say the majority of people are that way, so there's a but there. So it's not just a reasonable person, it's a reasonable person that's well-informed and apprised of the relevant stuff. So in other words, someone who's not prejudiced, and also someone who's not ignorant of, say, historical disadvantage or obvious things about certain disadvantaged communities. And last, this is something we're going to look at again in greater detail later on, but how the government can generalize, right? So a court's going to give the government a bit of breathing room here. I'm going to tell you this again in a bit, but that's why I don't feel like there's a lot of responsibilities for the government, right? The government has to think of a lot of things to pass a law, and you might think that it's really hard for the government to anticipate all these things, and so arguably the courts always, strike down laws, and the government's just doing its best. Specifically regarding what I mentioned about the government anticipating unequal impact, right? Again, this is my opinion, you might disagree with me, but it has to anticipate the impact of a law on all the groups who are affected by the law and proactively show in the design of the law that it takes into account that potentially differential impact. Well, the court at the end says it's okay for the government to generalize. So it's going to give the government a little bit of a respite there and say, the law doesn't have to be perfect, right? So in that case, the government can generalize and say people under 35 generally have an easier time getting a job. So it doesn't have to start, right, not in the specific purpose of the law, but in the underlying kind of statistical assumption, right? The government can use that statistical assumption without saying, well, that might not always be true. There's certain groups, although under 35, say disabled people, who might have less access to a job. So the government's allowed to generalize in that statistical assumption at least a bit. Now we'll go through the case a bit more. This was the summary, the most important stuff, right? I'm at page 507, starting, right? First, it's a unanimous decision. Again, quite interesting, as you'll recall from last week. First, right, there's a rhetorical exercise. So the court doesn't just say things, right, in the law. The court says things a certain way and says things, right, implicitly. And in that case, having the court unanimous implicitly suggests that it is the law, that there's certainty about the nature of the provision, how it's to be interpreted, and also that, right, it's the correct interpretation of the law and that it won't be changed in the future. And as you'll recall from last week, it's not actually that common for the Supreme Court to be unanimous. you have page 507, that's where the court gives these definitions of equality and discrimination, says basically what I said, that they are best construed ideals or aspirations, right? So often we'll try to simplify legal standards for you, right? But that's as simple as it can be. And that's because equality and discrimination are different, right? They are guarantees that are underlain by concepts that are intrinsically elusive, right? Unclear, in other words, right? They're concepts that lack a precise definition, are hard to pin down and define because they appeal to what the court calls some of humanity's highest ideals and aspirations, which are by their nature abstract and subject to differing articulations. And I would add that change over time, right? So of course, our conception of the disadvantage faced by people in our society today in 2021 is not the same as it was in 1982, and arguably the nature of the protections afforded by Section 15 of the Charter is called to change and often to be expanded as we further realize, right, the nature and magnitude of the barriers faced by certain groups in our society. Then you have 508 and following, right, the courts below, not particularly relevant. One court found that it infringes upon Section 15, so it's discriminatory, right, discriminatory distinction based on age. And then another court below said, right, it is, but it's saved by Section 1. So you'll recall from last week, Section 1 is this additional limitation, right? So when you've met this test, right, this is the main test that says you are infringing upon Section 15 of the Charter. In other words, your law is discriminatory within the meaning of the Charter, which protects the right of people not to be discriminated against, right? What happens then, it's not valid, right? That's what the Constitution's for. There's a protection of the right because it's an important right, like the other rights in the Charter. And how do we recognize that it's important? By making your law invalid, right? Well, it's not that simple because Section 1 says you can infringe upon charter rights in certain circumstances, generally when it's a reasonable limit, because the government, right, would always be limiting rights, especially rights that are as the court says, elusive and broad as this one. And Section 1 can have a further limit. So Section 1 can say, well, we've got a good reason, not a good reason within 15.2, right? But generally, we're trying to achieve a noble purpose in a proportional way, and therefore the law should be allowed to infringe upon the right. And Section 1 applies to all of the rights under the Charter. But again, the specific tests for that and the ways in which Section 1 works is not something we're going to look at in great detail. And then the test, right, is from the court cites quite extensively McIntyre in the Andrews case. That was an even earlier case from the Supreme Court, so before 1998, right? The court confirms a lot of the principles that were mentioned in that case. If you're confused about McIntyre, Jay, it's basically the court, right, restating these various principles that had decided in an even earlier case that was decided more shortly after the Charter was passed. Then page 517, right, you have this contextual approach. Look at the impact of the law, not just its purpose, not just whether there's discrimination in the text of the law, but whether it has, in effect, a discriminatory impact. Then you have definition of discrimination from an earlier case, page 518. Pretty helpful, right? Because, again, it's a concept that's hard to pin down. The distinction, whether intentional or not, based on characteristics of individuals or groups, right? that have the effect of imposing burdens, obligations, or disadvantages on the individual or group, not imposed upon others. So that's where the equality and comparison comes in, right? So not imposed upon others, or withholds or limit access to opportunities, benefits, or advantages. So the opposite, right? Either we take something away from you, right? Like, your right to your land, say, or we don't give you a right. Like, for instance, a driver's license, right, works both ways. And specifically, that's significant and remains significant today, distinction based on, right, characteristics attributed solely on the basis of association with a group will rarely escape the charge of discrimination. Does that mean we assume Jews are, say, richer? That might be an example there. It's what we call a stereotype. So assuming that people have certain characteristics, and generally because that's what we've done in the past, and generally it's not correct. Stereotype is generally not correct. And so you have a discussion around 521 and around there of the various steps. What I want to emphasize, though, is what I said earlier. Even though it's not a step, you have to remember about the grounds. So not just the distinction that's discriminatory, but one that is based on the grounds. And that's significant because you can't just come into, say, a specific fact pattern and assume that the distinction exists, because it has to be based on the grounds. In other words, why is that relevant? Well, if it's a ground, it's not that complicated. So here, Mrs. Law comes in and says, this is discriminatory to me based upon my age. Age is an enumerated ground, right? So it is presumptively a distinction that's covered under subsection 15.1 because it's listed in there, enumerated. If it's not, it can still be caught under the provisions because, as I said, it's not limitative, right? That's an analogous ground. But you'll have to show that. So there's a third step there in some way, right? If it's not an enumerated ground, it can be an analogous ground, but that will have to be shown. And generally by using the purpose of the law, right? The purpose of section 15, sorry. So by showing that, like age and race, for instance, right, gender orientation is something that offends, right, discriminating upon people based on that offends human dignity and the various things I said, right, plays into stereotypes, people who've been historically disadvantaged, prevents their full participation in Canadian society, right, and so forth, right, this hard to pin down definition that we've already discussed quite a bit. And page 524, within the test, failing to take account of historical disadvantage really reduces the likelihood that the law is going to be valid, right? So we expect the government to, right, take due account of both the impact of the law on various groups, as I've mentioned, but also the historical disadvantage. And often that's going to mean the impact, right? Often people are going to be impacted more because they've historically been disadvantaged, and the court says, right, we expect the government to take that into account before designing and passing the law. And then you have another example, page 526, of a distinction that is not discriminatory. In that case, distinction between inmates, so prisoners in one province and another. Well, there's a distinction, right, based on nationality, but it's not discriminatory, right? And it's not based on prisoner status significantly, because as I said last week, prisoner status is not an analogous ground, but they're both prisoners. So the distinction is not based on that, but based on the province they're from, right? But it's not a distinction that's discriminatory within the meaning of subsection 15.1. Why? Again, because it doesn't play in that historical disadvantage, right? We don't have a history of discriminating against prisoners from Alberta as opposed to prisoners from Ontario, and, right, having these people be lesser participants in Canadian society and so forth. Then you have human dignity and freedom around the same pages that are mentioned, that I mentioned earlier. This is helpful because, again, on an exam, you'd have to give a precise page number on a paper. If the exam's closed book, you'd have to give a precise page number, not a reference to the headnote or the case summary that comes at the beginning. Then you have the comparative approach as defined in the following pages, 530 and following. For the reasons I mentioned, this is no longer as relevant today. Not relevant in the sense of finding a comparator group. So the person that we compare you to is not as relevant, right? So defining who that person is, what are their characteristics, how they differ from you, that's not as relevant. But section 15 is still intrinsically comparative, right? Because for there to be discrimination, you have to be treated differently from somebody else, and that means there has to be a distinction, and therefore you'll have to show that that somebody else exists and that somebody else is treated differently. So the distinction is relevant. The identity, the precise identity of the person you're being compared to is not as relevant. Then the standard of the person that I mentioned, right, subjective, objective, and informed. That's at pages 533 and following. Stereotypes are mentioned at page 535, right? The contextual factors are all enumerated there as well. Human dignity, historical disadvantage, also mentioned, page 536. And there's a significant comment, right, page 537, that doesn't mean that there's an assumption that people are treated discriminatorily. And that's significant, right? So, as I said, we expect the government to look at historical disadvantage. So the government, when designing a law, is going to be expected to look at the impact of the law on various groups and the ways in which the various groups has traditionally been treated. But, right, of course, what that means in practice is if you've historically been disadvantaged, it's more likely that the law is going to discriminate against you if the government hasn't taken that into account, right? We look at whether the government took that into account because it's more likely that the government is going to discriminate against you again, or is going to have a law, right, that doesn't take into account, so that has a equal treatment, but that doesn't take into account that historical disadvantage. We have to be careful, page 537, that doesn't mean that there's a presumption, just because you've been historically disadvantaged, right, that every time there's a law, it does discriminate against you. You still have to show the various things under the tests that we've mentioned. Again, there's discussion of the relationship between the impact and the ground. That's all stuff that's expounded upon in very great detail. That's all very intuitive, right? So we expect the law's impact or the law's purpose to have something to do with that disadvantage or these characteristics. Otherwise, distinction is not discriminatory, right? Because it doesn't make a distinction based on the characteristic. The characteristic might be irrelevant. That's basically what the court says. I do want to get back to this idea that I've mentioned of right, the government being able to generalize. Why is that relevant? Because the court does give some wiggle room to the government. You might argue there isn't much of it. That's relevant because there's a line that's drawn that we'll look at, I think, next class with what we call a positive obligation. So generally, right, this whole framework that we've looked at is about striking down laws, right? Essentially, right? You can be discriminated against by a federal agency, for instance, right? But most often, the use of Section 15 and constitutional rights more generally is going to be to strike down laws, right, that are discriminatory. So saying the law isn't valid because it infringes upon the Constitution, which is higher. Well, striking down is, right, preventing the government from doing something, right? So the government's going to pass a law, and then the court's going to say, well, no, that's not valid because you are infringing upon the Constitution. Significantly, there's something that we call positive obligations. I just want to mention those somewhat briefly because we'll look at it in great detail. And generally, this is a distinction that's very significant, right, in what people can sue for. So if the government passes a law, right, you can come in and say you want it to be struck down. But you can't do the opposite, right? You can't go to court and say, I want, the government to pass a law because my status is bad. You can't come in and say, I need a law that gives me a house because otherwise I'm discriminated against based on my socioeconomic status. Or I want the government to give me money because otherwise I'm discriminated against based on my socioeconomic status. That would be a positive obligation. And for very legitimate reasons, right, courts aren't governments, and generally what they do is check legislative power, check how the government has exercised its constitutional power to pass laws, not pass laws for the government. It's not what courts do. And therefore, there's no such thing as a positive obligation. So, for the government to pass a specific law, and similarly, there has to be an impugned law, the Supreme Court calls it. There has to be a law that's being contested. The plaintiffs can't, right, come to court with an issue that doesn't relate to an existing law. So there's no such thing as a positive obligation. That being said, it might be interesting to reflect upon how the wiggle room that's given by the court to the government might amount to a positive obligation, right? So, of course, court isn't going to say to the government, you have to pass this law, but it's going to come really close. It's not going to do that in a vacuum, of course. It's not going to say you have to pass a law when there is none. But the court is going to impose very stringent obligations upon the government that aren't necessarily in the text of Section 15, in fact, are not in the text of Section 15. And these are the obligations I've mentioned, for the government to consider proactively the impact of a law on various groups, and also for the government to consider historical disadvantage. And if the government doesn't do that, it might have a law that's very simple, that achieves a simple purpose, right, that just treats everyone the same, and the government passed, relatively straightforwardly, and the court is still going to strike it down. So pages 541 and following, right, you have this discussion of judicial notice, which I've already explained in quite a bit of detail. You have the citizenship example I mentioned as well. Then this discussion, I'm just mentioning it for you to not get confused. Pages 546 and following, court says the second and third steps. As I've mentioned, now for our purposes, it's 2 steps, right? So whether the third step exists, basically the purpose of Section 15, right? It doesn't exist for our purposes. There's 2 steps, but it's really the same because they're broken down. Then the contextual factors, right, in the summary, very helpfully provided, pages 549 and following, which even though it's a summary you can cite to as opposed to the headnote. As I mentioned, the ameliorative purpose is now part of a separate analysis. That's not, that's one of the two things in the case that I've mentioned that are no longer correct statements of the law. And then, right, the court applies to the facts of the case, pages 553 and following. For the reasons I mentioned, the facts of the case are not that relevant, both the Supreme Court statement of the general principles that apply, but also not particularly relevant for our purposes because we're concerned with these very principles. But the court says, right, for the reasons we mentioned, that a distinction, even based on an enumerated ground such as age, can just not be discriminatory because it's not stereotypical, doesn't play into historical disadvantage of people under the age of 35 for our purposes. And the court says, right, pretty interesting statement based on the generalization I mentioned. Again, you're free to disagree with me. You can discuss that in our discussion session. But on how much wiggle room the court says, very interesting statement. We'll close on that, page 561. Parliament is entitled to pass a law, the court says, under these limited circumstances at least, is allowed to pass remedial legislation based on generalization. So court says, right, we do impose pretty stringent obligations, but at least based on the statistical data, you as the government is allowed to generalize and use that as a basis to design your law.